absence disables their ability to defend themselves effectively. These are very substantial questions, but the court has declined, and when we have sought to appeal their ruling, and the law clearly says we have a right of appeal and uses the mandatory language, shall. The court, through the judge advocate, has declined, and even declined to hear our arguments. We are leaving this place very sad, not able to know whether the court is still going to function or it's the judge advocate, because he has totally hijacked the proceedings.
We maintain, well, our clients insist they are not subject to martial law.
Yes.
It's the reason they have declined to take a plea. We have persistently put across that argument. We have invoked all the relevant laws to back up that argument that our clients are not subject to military law. They are not subject to martial law, and therefore this court has no jurisdiction to try them here. So they have refused to submit to the jurisdiction of this court, and that is the reason they are not taking a plea. And it's one of the reasons we sought for leave. No, actually not leave. It's one of the reasons we had made the application to have a reference to the Constitutional Court. The jurisdiction of this court, including those matters where the Constitutional Court has pronounced itself persistently even after the Kabazikuluka decision. Because every matter that has gone to the Constitutional Court, the verdict has been the same. The pronouncement has, and it is self-executing. We get a shock of our life when the prosecution said, we need an order of enforcement, of execution. When indeed the constitutional pronouncement or pronouncements of the Constitutional Court are self-executing. So it's we still maintain our clients are not subject to martial law, and this tribunal has no jurisdiction over them, and they will not take a plea before them. That's exactly what has happened today.
We hope that was
the right for one to say, I'm declining to take a plea.
no,
And it's up to them to record whatever plea they want, whether it's a plea of guilty or not. But in law, once one declines to take a plea, they are obliged to do to record a plea of not guilty.
But they should also record that our clients refused to take plea. Therefore, the court has entered a plea of not guilty. So we are hoping that the registry will keep accurate records. The registry which the judge advocate tells us he is in charge.
Bakiriyansi baffe bawakanya obuyinza bwa kooti eno okubawozesa mu nsonga nnyingi zonna zetayinza kuddamu wano, naye zonna nga mulabye nti kooti eno terina buyinza kuwozesa misango gye bagamba nti gyazzibwa Kenya oba Greece oba Geneva, n'okuba nti babaleeta nga tebayise mu mateeka amatuufu ag'extradition, n'okuba nti nno kooti eno terina buyinza ku ba civilian. Ekintu kooti etaputa ssemateeka kyezeddamu enkya n'eggulu entakera n'emisango gyonna ne tugireeta wano. N'ekitwewunyisizza buli application gye tuteekayo dismissed, buli ke muteekayo tukagobye. So buli kye tuleeta bagoba bugobi. Awo naakula etteeka ssemateeka kirambika bulungi Article 137 nti singa oli pate emu bw'ebeesabye nti ensonga zino zigende mu kooti etaputa ssemateeka, ono bano tebalina buyinza buzigaana na zitaputa, balina buyinza buziframinga. Naye omulabye amenye ssemateeka ey'ennyingo 137 ye n'agamba nti tagenda kuziwaayo, agaanye. Ekyokubiri, akawaayiro 225 aka UPDF Act kagamba nti atamatidde na nsala ye mu nsonga zonna n'engeri proceedings ezitambulamu oba omusango gye baguddukanyamu waddembe okwekubira endulu mu kooti esingawo. Ekyo nakyo agambye nakyo tugaanye. Obuyinza nga judge advocate yalagira nga senior counsel wabagambye nti judge advocate nga akomandinga bukomandinzi kakati ye yefudde amateeka. So judge advocate yeteeka kyalagira ye kati biragiro. So n'olw'ensonga eyo client waffe ye bakirayinti baffe bayinsistinga nti tebalina bakirayinti baffe bayinsistinga nti kooti eno tebalinaako buyinza era kooti teyinza bagaana kugenda mu kooti etaputa ssemateeka, teyinza bagaana kujulira. N'olw'ensonga eyo era ne bagaa tebagenda kuteekinga puli, bo bali ne basalawo nga bwe basazeewo nti bawandiika ekyo. Neffe kye tugamba nti balina okukiteeka mu record, kukikapukyalinga bulungi mu record mu biwandiiko nti bakirantisi baffe bagaanye okuteekinga puli olw'ensonga nti tebakkiriziza mu kooti eno okubawozesa, teyina buyinza, teyina buyinza bwonna mu mateeka kubawozesa, era bawozesa mu bukyamu, ebakaka bukasi okubeera mu kaguli n'okubawozesa. So n'olw'ensonga eyo tugenda kusala tulina enkola endala gye tugenda okulaba bwe tukikolako. Titutudde kyetwagala obbakakasa titugenda kuba nga tuddayo nga legal team, tugenda kutuula ate era tutakule emitwe era tubikkule amateeka amalala. Bwe baziba lino ekkubo nga ate tukwata eddala, bwe baggala lino nga tukwata eddala paka lwe tunaafuna obwenkanya.
That questions are fit for reference to the Constitutional Court. Mr. Chairman, a judicial officer to choose themselves. Regarding issue number 1, it deals with whether the offense under offenses relating to security, section 128, F of the UPDF Act defines the offense. Mr. Kalibala said that it does not define the offense, together with Mr. Mpanga, and their view is that because it says a person who omits or does an act. When you cross-reference with other laws, an offense can be constituted by an omission. It can also be constituted by an act. Even in the penal code, an unlawful act or an unlawful omission can constitute an offense. There is also a requirement in the offense that the intent must be to prejudice the security of the defense forces. Those are matters once alleged that are supposed to be subject of evidence, and the burden is on the state. But at the moment, this issue is premature. It is determined with evidence, and this court can decide that matter. There's also an issue regarding whether the trial of civilians in general court martial is consistent with decisions of civil courts in earlier cases. And one of the cases cited is the case of Honorable Michael Kawaziguruka versus the Attorney General. Most other cases cited, including retired Captain Amoni Byarugaba and Semuju Abduminana, we are referring to that decision of the Constitutional Court. But the decision is pending before the Supreme Court. And the orders and declarations made in that decision were stayed. So it would not be an authority that determines the position. We would rely on earlier authorities. The earlier authorities included the case of Hadija Namugerwa versus Attorney General, Civil Appeal number 4 of 2012, where they said the provisions of section 119, which is now 117 of the UPDF Act, is proper. And charges can be maintained under that provision. There is also an issue number 7, whether the General Court Martial has jurisdiction to deal with cases under the Firearms Act. The UPDF Act defines a service offense to include offenses under the Act and those under any other act for the time being in force committed by a person while subject to military law. And in the Supreme Court has pronounced on this in Attorney General versus Uganda Law Society, page 10. And in that case, it was a unanimous decision of the Supreme Court arising from a constitutional appeal. They only required that for an offense under an act other than the UPDF Act to be within the jurisdiction of the General Court Martial, it must have been committed by a person subject to military law. And what they required was to allege and show that the accused persons committed either of the two offenses while they were subject to military law. That is the link they require. And the applicants have not shown that that link is not in the charge sheet, and it is the burden on them to show that there is no link. It is not alleged that these people were subject to military law. We also wish to point out that there are procedural safeguards for the trial of persons before the court, including presumption of innocence, burden of proof, and these are matters for a trial court. These are not matters that require constitutional interpretation. With that, I hand over to my colleagues to continue.
Learned friend, Captain Ambrose. I'll begin by quoting Article 132, Clause 4 of the Constitution. It says that the Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. My Lord, the Supreme Court has severally decided that these courts have jurisdiction to try the accused persons. And my land colleagues on the other side, repeatedly citing the decisions of the Constitutional Court, would be in contravention of that specific article. My Lord, I will reply to the other general issues, specifically on Regulation 63, Regulation 2, and Regulation 69. My Lord Chairman, the General Court Martial operates under a framework of the UPDF Act, which ensures its independence. The Act provides a clear separation between the administrative functions of the High Command and the judicial functions of the General Court Martial. My Lord, I refer you to Section 14 of the UPDF Act, Cap 330, and Section 195, so one establishes the General Court Martial. My Lord, while the High Command may oversee the general military administration, it does not interfere with the judicial making process of the General Court Martial. Members of this court, including its chairman, are carefully selected and sworn to administer justice without fear or prejudice. Although this is under Regulation 14 of the Uganda People's Defense Forces regulations. They are guided by the principles of fairness and impartiality enshrined in the Constitution, Article 28, and the UPDF Act. The presence of the legal officers and adherence to established legal procedures further guarantees impartiality of the proceedings. This court has autonomy in its decision-making process. It conducts trials based on evidence, law, and legal principles, not directives from the High Command. The decisions rendered, furthermore, the decisions rendered are subject to appeal and review by superior courts. By superior courts, I mean the Court Martial Appeal Court. This is provided under Section 225 of the UPDF Act. The relationship between the GCM and the High Command is administrative, not judicial. The High Command's involvement ensures logistical and institutional support for the Court Martial, but does not extend to influencing judicial outcomes. Now, concerning Regulation 63, Regulation 2, it is very clear the role of the judge advocate is to advise court on matters law. If the court disagrees with the decision, they shall record in the proceedings in its reasons. It does not mean that they are entirely binding, as one of the colleagues on the other side alluded to. My Lord, I give way to my other colleague to submit. That is all.
Arrest, rendition, and trial of formerly two accused persons, that is Colonel retired Dr. Kiiza Besigye and Haj Obeidul Taleh. Mr. Chairman and honorable court members, the ruling that was rendered by this court today morning settled that. And in that ruling, the court clearly pronounced itself in as far as the arrangement that is between the two countries, that is Kenya and Uganda. And my Lord Chairman, that arrangement is backed by the law. It's backed by the East African Community Treaty, of which Uganda is a party. Not only being a party, but it also domesticated that treaty. And the same thing for domestication was done by our neighbors, that is Kenya, also domesticated that treaty. So, Madam Chairman, under that treaty, specifically under Article 124, that addresses the protocol of peace on peace and security. And the article outlines the commitment of partner states to cooperate on issues related to peace and security. And my chairman to into motion or to put into practice that cooperation. That's when we see the coming up of that memorandum of understanding for the two states to cooperate on matters relating to security and cross-border crimes. Therefore, we also refer to this court the authority that my brother and senior colleague, Councillor Kwago, alluded to, the one of Amar, Awad, Omar, and 10 others. And my Lord Chairman, that's a very good authority, because it clearly highlights the role of states that are parties to the East African Community Treaty. Under paragraph 30, if I may read verbatim, states that we also observe that East African Community Treaty was domesticated in Kenya, Tanzania, and Uganda. In Uganda, Parliament enacted the East African Community Treaty Act of 2002 by virtue of statutory instrument number 29 of 2005. The East African Community Act Commencement Instrument 2005. It came into force apologies, I think I misplaced the paper. But the argument I'm making is that there indeed exists an arrangement between the two states, the two partner states, that is Kenya and Uganda. This one was confirmed by authority that was clearly and well cited by my senior colleague, though with blood interpretation from his side. But be as it may, my Lord Chairman and honorable court members, we submit that indeed the laws were followed. In other words, in the absence of the extradition treaty between Uganda and Kenya, this law applied squarely on both countries. Madam Chairman, also, and that one would not really need a reference to interpret, otherwise it would be a waste of God's time. Madam Chairman, on the other issue, which I earlier alluded to it and submitted on it, but maybe to add something that is that might be important. We really read all the authorities that were provided to us by our colleagues, and two things are cut across in all those authorities, and my colleague Gorko talked about it. There is a recent ruling. This one you may not need to refer to the Constitutional Court. And that ruling was very clear, staying the execution of the Kabaziguruka case findings. It is as plain as that. You don't need to refer to court that interpret this or try with civilians. It would really be absurd, very absurd. And my chairman, further on that, we also confirmed that indeed the decision, the authority that was cited by Steel Council Rukwago, the one of Abdunur Semuju aka Minana, the issues that had been raised in Kabaziguruka case were the same issues that were raised in Minana, and he can testify, he argued it. So, my Lord Chairman, it would be defeat of justice. And not only that, but also wasting court's time to now also apply to stay the execution of Menana. Though there has been an appeal, we are aware, and Council Kwago is also aware that there has been an appeal against the decision of the Constitutional Court. And we are yet to know the hearing dates. But, my Lord Chairman, we submit that we base the trial of civilians in this court on the decision or the ruling staying execution, the decision of Kabaziguruka. And therefore, in this matter, Minana cannot really suffice. It can't. As I conclude, my Lord Chairman, and your court members, I would also like to add something on the question of impartiality that my colleague talked about. That's whether the General Court Martial can be impartial on adjudicating matters before it, and the reference was made to Article 28(1). My Lord Chairman, my colleague addressed that, but to add something, under Section 207 of the EPDF Act, where rules of procedure and evidence that apply to civil courts can as well be applied to General Court Martial. That is in the law. And my Chairman, that goes back to the supremacy of the Constitution. Now, under that Constitution, it provides clearly two things: the impartiality of courts. So it's out of that law that is now 207, it applies to General Court Martial. So what my colleague said, and that article under 128(1) of the Constitution, and 2. So impartiality, really, it is there. This court is impartial. And my Lord Chairman, lastly, I wish to also add on what my colleague said, and that is on the procedure, on how you refer a question for interpretation to the Constitutional Court. My Lord Chairman, that one was settled by a Constitutional Court in Ismail Sergo against Kampala City Council. And justice Worms as he then was very clear, extremely clear. Where he stated that the petition, you can adjust that with the necessary modification, reference must show on the face of it that interpretation of a provision of the Constitution is required. Lord Chairman, what we saw today and the framing of questions was an appeal in disguise. An appeal in disguise. The questions, the way they are framed, we would actually say that the counsel for the accused persons would go under the Court Martial Appeal Court rules through appeal against the ruling that was rendered today morning. Other than casting a net, but let us see what comes out of the lake. The court does not operate like that, my chairman, and I pray that you should not allow that to happen in this court. And my chairman, that was also emphasized recently by the Constitutional Court Preference number 31 of 2010. That is Uganda against Francis Atugonza. And court stated that constitutional reference by the court that is determining the cause or a party to the proceedings who request the court, and this goes back to what my colleague and senior counsel Kalibara stated, that the court, so the hands of court are tied, quite absurd. They are not. That's why you're here. Well, Chairman, that statement itself, it simply puts a constitutional court into a position of applicability of the law, of the rules, which I disagree with my colleague. The Constitutional Court can apply the law in other instances, but as far as constitutional reference is concerned, it's basically interpretation, not applicability. Not applicability. Applicability is with the authority of court. Now, whether the court, I'm not saying this court, whether the court, any court, applies the law irregularly, that is a different matter. And there are channels. You appeal. You appeal. That's what he told me. Now, and lastly, my Lord Chairman, we pray that my Lord Chairman, if I may be protected, unless the law has since changed. But my Lord Chairman, lastly, we pray that from my side, because my senior colleague is going to give it a final push, we pray that you really be pleased with us on the law, and especially where you are dissatisfied with the decision or the ruling of court where you are supposed to go. We so pray. And my colleague, my senior colleague, is going to bring this home.
When you look at Article 142, appointment of judicial officers, paragraph 1, the Chief Justice, the Deputy Chief Justice, the Principal Judge, a Justice of Supreme Court, Justice of Appeal, and a Judge of High Court shall be appointed by the President, acting on advice of Judicial Service Commission and with approval of Parliament. Now, our honorable colleague tried to dramatize that here you are a judge, you are a complainant, you are so that you cannot get a fair trial before this honorable court. The same person who appoints these justices and judges is the same person when you look at the section 194 of UPDF Act. The same person that appointed the court members, the instrument which you read to the accused person, that is the commander-in-chief, is the president, and it is the same person. So where is impartiality in that regard? So that one does not require any constitutional interpretation. Please. Section 208 was also attacked of the UPDF Act. I want to implore you to look at section 4 of the Penal Code. Section 4 of the Penal Code Act is about the extent of jurisdiction of courts. And it states the jurisdiction of the courts of Uganda for purposes of this code extends to every place within Uganda. Notwithstanding subsection 1, the courts of Uganda shall have jurisdiction to try offenses created under Section 23, 24, 25, and 26 committed outside Uganda by Uganda citizens or person ordinarily resident in Uganda. For avoidance of doubt, the offenses referred to in subsection committed outside Uganda by Uganda citizens or a person ordinarily resident in Uganda shall be dealt with as if they had been committed in Uganda. And those, under those sections, those offenses are treason and aiding mutiny to police officers, that kind of offenses. And now when you go to section 3 of Anti-Terrorism Act, Section 3 of Anti-Terrorism Act, territorial jurisdiction of courts of Uganda in relation to offenses under the Act. The courts of Uganda shall have jurisdiction to try any offense prescribed in this Act, where committed, if the offense is committed in Uganda or outside Uganda. So, it's, the section puts down all circumstances under which the offense can be committed. Then offenses committed outside Uganda, to which this section applies, shall be dealt with as if committed in Uganda. So this section is almost the same wording as section 208 of the UPDF Act, where these officers are asking, where do we get jurisdiction to try an offense which was committed in Kenya, Switzerland? It's not what is special about this. It's not news. What should be interpreted by the Constitutional Court? So jurisdiction extends outside Uganda according to the statute. And we earlier stated that jurisdiction is a creature of statute. Therefore, there is no need for such a section to be referred to the Constitutional Court for interpretation. What would you be interpreting? Man and all court members, we do believe that our land colleagues are aware. They are citing Kabazuguruka case, but they are aware that that case, if you are to implement it, there must be execution. You go and extract execution order. And if you get that order, we would not, this honorable court would be tied. It cannot proceed in trying the civilians. If an execution order, and you know how to get execution order. If you don't know, then you need to go and revise how your criminal procedure. So it would be frustrating. The highest court of the land, I read verbatim how they in the result, we allow application and make the following orders: execution of and or giving effect to the orders and declarations issued by the Constitutional Court in the Constitutional Petition number 45 of 2016 between the parties hereto are stayed until disposal of applicants' intended appeal. Who are you to go against the order of the Supreme Court? Chairman and all court members, that is the position of the law. And in case it is not, if we don't proceed, personally, I think I would even be prosecuted to give a reason that we don't have jurisdiction. Chairman and all court members, until otherwise, as of now, we have jurisdiction to try civilians. So there is no matter that should be referred again for constitutional interpretation. I submit.
Is that some learn and some do not learn, even when in attendance. Council Kalibala, Council Mpanga, Council Karua, and Council Lukwago went into further detail about the constitutional provisions, the questions vis-a-vis the UPDF Act and the Constitution. I am disappointed that they might not get a financial benefit to that, but they offered it free of charge for us all to hear and listen. The actual fact that we sit here and says that does not raise a question, that is a question, is the actual reason as to why we should be in the Constitutional Court on such matters pertinent to this matter. I also want to state in general rejoinder that it's not the duty of the prosecution to frame questions that we want the Constitutional Court to address. And nor is it the duty of this Honorable Court, with all due respect, to usurp powers of the Constitutional Court under 137 to interpret questions posed by the parties. I also want to state unequivocally that there are two legs within the Constitutional Court. If it may please you, I will substantiate on the two legs. On the two legs, there is one where the court deems it fit to raise a constitutional question. That is one leg. And in the wording of the Constitution, they use the word may. I believe that you as officers of the UPDF understand command, order, and all that. The second leg of that Constitution, Article 137, 5B, gives latitude to the parties to escape the tyranny of a court, tribunal, or a disciplinary committee by allowing the parties to pose a constitutional question. And we didn't move under the other leg one. We used leg two to protect and defend the rights of the accused persons. And that leg in the Constitution, it says shall. It is coiled in mandatory terms. The Supreme Court has been in position to guide in a number of authorities about the coiling of the Constitution and the word shall and may. And the framers of the Constitution, of which Dr. Besigye, one of the accused person was, is very clear and instructive. So it's our duty to ask that the professional UPDF under Article 208, the professional and professional soldiers should respect the command and the supremacy of the Constitution, of which we are all here to defend. Members of the General Court Martial, I also want to mention that when the prosecution wants to phrase its own questions, it shall present them before the Constitutional Court. We have framed ours, and we are saying this matter warrants a constitutional interpretation. Members of the tribunal, I do not understand the obsession with the Kabazukuka case. My senior has already alluded. I said the General Court Martial, Tribunal, or any disciplinary committee. And with the word court, if it appeases your ears, I shall maintain that. Professionalism means respect to the rule of law. None of you will be hurt, or there is nothing for you to lose if you refer our questions to the Constitutional Court. And in the way, counsel lied to this honorable court by saying that this court's hands are not tied. Actually, they are tied with chain and shackles. And I will address in broader perspective about the MOU talked about. That MOU is alien to us, and it's not anywhere within our knowledge. All that we are so sure of, Article 79 of the Constitution only gives powers to Parliament to make laws, and also has a condition that no one else can make laws that have force in Uganda. Whoever that MOU might have had his own wishful desires, and that's not our problem. Our problem is that the law of the land must be enforced the way it is to the latter. And also, in the most severe, I want court to take judicial notice under the Evidence Act, as taught by Senior Karibala, that even in the most cases of Jamil Mukulu, there was an extradition from Tanzania. As to whether the accused person did not enjoy that benefit is also another phenomenon we are about to explore. I also want to state that the issue of impartiality has been largely misunderstood by my colleagues. It's not about the members of the court. No, it's about structural issues rooted in the UPDF Act vis-a-vis the Constitution of the Republic of Uganda. We do not have any desire to impute the credibility of the members of the panel, and we have less appetite for that detail. I also want to state that, having said so, these are our questions as to whether they desire to make submissions challenging any of the interpretation. Unfortunately, none is qualified. None of us is qualified to authoritatively do that, save from the Constitutional Court. And trying to do that is violating and usurping the powers of the Constitutional Court and molesting and defiling the Constitution of this Republic. The idea that we quote Kabaziguruka and leave other cases that have been decided and not appealed is appalling. And should be the duty of the officers of the UPDF to maintain the stature or the desire for the UPDF to be a professional army. And finally, when a matter arises, when a constitutional matter arises, it has to be referred for interpretation. Otherwise, again I state, none of us is qualified to interpret the Constitution. And another rider is failure to respect the interpretation of the Supreme Court, also tantamount to violation, molesting, raping, defiling, and abrogation of the Constitution of the Republic of Uganda. We desire, it's our desire, that we do not want the UPDF and its institutions, most especially the General Court Martial, to tread and trend that way. Again, we do not know about that MOU being quoted. We do not know it as under the laws of Uganda. We also do not, we are certain that it did not conform to Article 91 of the Constitution of the Republic of Uganda, and whoever made it can as good as use it to light a fire and a charcoal stove for their own benefit. Thank you so much.